Ladies and gentlemen, lend me your ears and your eyes. Diva Divine Light, live from Brooklyn, New York.
Know your lane for what you saying, yo. I'm sitting with my 9 million with the dilly, yo. When I be on the mic, yes, I do my duty, yo. While I'm in the club, I be while in the studio. You don't wanna vibe, nigga, really and truly, yo. My main thug, nigga named Julio, he moody, yo. I'm a nigga that'll slap you with the toolie, yo. Bitch, nigga scared to death, act fruity, yo. Fuck that, look at shorty, she a little cutie, yo. The way you shake it, make me wanna get all in the booty, yo. With no delaying for what you saying, yo.
Diva Divine Light.
Really my heart to me. Fucking see what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fucking see what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you.
You're watching Diva, the Divine Light. A fun-loving, caring, passionate person who talks about sex, celebrity, and real-life issues, and even abuse. So hit that like button and make sure you share the show.
Really my heart to me. Fucking see what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fucking see what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fucking see what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fucking see what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you.
Here comes the pitch, and it comes in wide. On the ball.
Yo, hello everyone. Good evening. Good evening, y'all. What's up? Well, I'm feeling a little bit better today. Not 100%. I wound up throwing my guts up in the middle of the night this morning, shall I say. That was not good. I'm adjusting my microphone, y'all. Give me a second. I know you guys already heard the rest of the transcripts. I know everybody else already finished it before me. It's all right. You know, like I said, I would have done it yesterday, but I really wasn't feeling up to anything. You know, I pretty much was laying down for most of the day. So, hello, everyone. Welcome back. Welcome back, everyone that's in here. Let me shout everybody out. Hello, Queen. Thank you. Yes, my son is 13. He's a big boy now. He's officially a teenager. Hey, Candy. What's up, Tasha? Hey, Kat. Hey, Shirley. What's up, Mama? Hey, Just the T. What's up, baby? You driving and listening? Okay, Mama. Be safe, please. You got a snowstorm? Oh no. Yeah, and there's supposed to be like tornadoes going on in Kentucky. Okay, snowstorms in Chicago, tornadoes in Kentucky. It's pretty chilly out here, not that bad in New York. Hey, Iced Out, what's up, Mama? What's up, Just the T? All right. So, oh boy. Well, I was thinking before we get started, or shall I just get started? I don't know. Should we listen to... I enjoyed my birthday. You know, I was home. I didn't get to eat any cake. I just was sick, laying down. I barely ate. But it was okay. It was all right. I'm alive. Thank God. Gracias a Dios. Thank God. So my stomach today is kind of weird too. I threw up my guts this morning. It was crazy. I was upset. I was like, oh my God, I was feeling okay. And then all of a sudden in the night, and it was just like a lot of like bile. It wasn't even any food in my system. You know what I mean? So yeah, I went through it. But my son was okay too. He enjoyed his day, He had a good day at school. He didn't fight nobody. He had a really good day. He helped out with his classmates and what they needed help with. And today he had another great day as well. They got him sitting in the 8th grade class, and he actually likes it better. The boys there are more mature, he says, so he's used to talking to older kids. Kids on his age are not on his level. So I guess he feels different when he's around kids his age. So he feels more comfortable with kids a little bit older than him. And that's natural. I get it. You know what I mean? I was like that too. So, oh, Fabio might help me, you think? Hey, Shirley, what's up, mama? Welcome back, baby. Well, I'm going to read it on my own in the meantime. Unless somebody wants to jump in and help me out, that's on them. But there was a phone call. Rkelly made 2 phone calls to 2 people, to that guy Andre and to Storm Monroe. He also spoke with Spit and Fire, and Rkelly is desperate. He is so desperate and so narcissistic. It is funny as fuck. Okay? It is hilarious to see this man like this. He's like, he really, really thinks that because of Azriel's testimony, that is the reason why he went down. Like, if it wasn't for anybody else, everybody else he would have gotten away with. But for Azriel, he didn't get away with this crime. The government convinced her to testify against him. So that's a problem. Rkelly, you're crazy. Sit your narcissistic ass down and stop it. Stop. You're looking crazy in these streets. Seriously. And your fans look even more crazier. Like, seriously. Y'all need to stop. Oh my God. It is the funniest thing to see. It is the funniest thing to see. How to spin fire at all people. Yo no sé. Es que Rkelly's desperate. He don't know what to do. He does not know what to do. He is desperate. He's scared that he's really going to spend the rest of his life in jail. Good. This should teach you a lesson. You should learn your lesson. You do the crime, you do the time, my man. And the crime was you were messing around with minors, and you were committing crimes. And you had people help you out to commit these crimes. Period. And your girlfriend just led us to the storage. That's it. That's all. That's what your girlfriend did. She admitted to all the shit she went through. That's what she did. That's what happened. All your girlfriends decided to say, well, you know what? He did commit crimes. Yup, I was abused. Yup, I was a sex slave. Yup, he did do those things. Yup, thank God I'm gone. And yup, thank God he's sitting in there. I don't really want him to go to jail for the rest of his life. I just want him to do some time for some crime. Because a lot of them feel that way. Some of them want him in jail for the rest of his natural born life, and some feel like he don't need jail for the rest of his natural born life. Just a little bit of jail. But he needs jail. And he also needs help. And he's going to get help, supposedly, allegedly, I guess. I would hope so. When he goes to prison now. Because that's the next thing that's going to happen. He's going to leave the MCC to go to a prison. So, well, the last where we left the transcripts, we left it on page 16. And at this point, the judge was speaking. If I'm not mistaken, it was the judge who was speaking at this point. Let me make sure. No, I'm sorry. Right now, it's Bonjean. Bonjean who is speaking. I'm sorry. We left it off where Miss Bonjean was finishing up her closing statements. All the money alone, Sly Fox done difference. You know, hey Cherie, what's up, baby? What's up, Karen Johnson? Hi, baby. What's up, my ladies? Yeah, Sly Fox has done a lot. A lot of them have done a lot. Yeah, they've done a lot. You know, I have to give it to Sly Fox, you know, Sharon, who have been trying their best to help out with things, you know. Let's see, who else? I think those two women are the most diehard women, I guess, that are for Rkelly. I don't know. Don't you guys think? Sharon and Sly Fox? Sharon and the flower pot lady and the dry fox are the only two that I say that have really tried to contribute to helping his causes, you know, trying to let the people know that this is Rkelly's narrative and this is how we're going to spin it and this is what we want the people to believe. Oh, Dottie too. Dottie's done a lot of reporting. Yes, she has. But I don't think she's helped as much as Sharon and Sylvia, you know, like you know, trying to get the word really out there and, you know, being a groupie, a real true groupie. Yeah, that's what I think. You know. So let's continue on this. I'm gonna read this. So Bonjean continues to say that it is symbolic that the government wants that for some reason. Why? Because he's Rkelly, that's why. And that is not fair. So now I've made some remarks in my sentencing memorandums about where I think the government should spend their resources and time. But just because you give Rkelly 50 years, 100 years, doesn't mean you have solved the problem of child exploitation in this country. I can agree with that, Ms. Bonjean. I agree with that statement you made there. I can agree with that. Just because you give Rkelly 50 years or 100 years, that's not going to stop the problem. but it will make an example within the music industry. It will make an example within the music industry for these men and these artists, male or female, out there to not do shit like this anymore. Because it's not going to be tolerated anymore in this country. Period. At one point, it was tolerated, but no longer will it be tolerated. We are now officially in 2023. We are in the 20th century. Okay? So she says, now I've made some remarks in my sentencing memorandums. 50 years, 100 years doesn't mean you have solved the problem of child exploitation in this country. There's plenty of child exploitation, but giving him 100-year sentence, 2-year sentence doesn't solve the problem. This is still an individual, and the sentence needs to be appropriate for this individual, taking in his individual characteristics and, yes, looking at the conduct in this case, which we have gone through extensively. As far as deterrence goes, well, the specific deterrence is not a factor. Why? He's already incapacitated. How does this specifically deter him? He's already got a 30-year sentence. And that sentence, again, will likely take him through the rest of his life. The general deterrence, as I argued, I think the public has a sense of how serious these offenses are. I think if anyone has provided a general deterrence, it's Rkelly. In fact, I think most people look and go, geez, Rkelly, man, he's got the longest sentence in the history for this type of conduct, particularly compared to his other counterparts that are similar to him in terms of his fame and wealth. And like I said, Bonjean, that stuff that happened in the past, and we let it happen as the people let it happen. Because it was the thing of rock and roll and, drugs, sex, and rock and roll, right? Right. Well, not anymore. Me Too is here to run shit. It's not happening anymore. No more. In the workplace, on the streets, anywhere. It's got to stop. And these are just examples. Harvey Weinstein and Rkelly. That's the food, babe. Hold on a second, guys. And so I don't think that general deterrence is a problem. The public has been generally deterred already. In fact, if there's one person that no one wants to be on this planet, it's Rkelly. So they have accomplished both specific deterrence and general deterrence. Running this sentence consecutive is not going to enhance that any further. So, Your Honor, I want to just reiterate. Hold on, guys. I forgot something. He's got the rice and the rib tips. Right. He's got the quart. I mean, the pint. What is that, a quart or a pint? Oh, you don't have to give him all that rice. Oh, God, Jesus Christ. I thought I ordered a small thing. Okay. All right. So, Your Honor, I want to just reiterate, Mr. Kelly, myself, on behalf, Mr. Kelly, we've never. Hold on. We've never minimized the crimes for which he was convicted. Okay. I'm going to repeat that. We've never minimized the crimes for which he was convicted. Thank you, baby. What, a wonton? Want one? I'm about to have some wonton soup, guys. Let's see how this holds me down. So, Bonjean in this sentence is saying that her, as his counsel, is not minimizing the crimes for which he was committed. In other words, all right, he did some of that shit. He did some of that shit. I'm not saying, he ain't do the shit he did, but he did some of that shit. Then she says, we have simply argued what we think is an appropriate sentence. We believe the guidelines range is appropriate under the circumstances and a concurrent sentence is appropriate. Again, this case could have been brought in the Eastern District and saved everybody a lot of time and resources. And Judge Donnelly could have factored in this additional harm. Josh, close the door. Again, this case could have been brought in the Eastern District and saved everybody a lot of time and resources. And Judge Donnelly could have factored in this additional harm. I can't with him. Bonjean, you are funny, girl. But that's why she's a lawyer. She does her work. I give her credit, She does her shit. But our position is that the guideline range adequately responds to the conduct that Mr. Kelly has been convicted of. There's no need to go above. And there's no need to run this consecutive because it's frankly overkill. And the government hasn't really provided a strong argument for why it should be consecutive other than he has a lack of remorse, which frankly, our position is they cannot say. And it is not our position at all that he lacks remorse. So with that, Your Honor, unless the court has any questions, that concludes my remarks. So now the judge says, I need to ask your client if he wishes to allocute. Mr. Kelly, would you like to make a statement on your own behalf before I impose sentence? The defendant, Mr. Kelly, says, sorry, Your Honor, but on advice of my counsel, I would not. The judge says, thank you. Kelly says, thank you. The judge says, any further from either side? And Ms. Apenteg says, nothing from the government, Your Honor. The judge says, okay. Okay. What's interesting in this case is that this case was filed first and would have gone to trial first, but for the fact that the COVID protocols, because we had 3 defendants and because of distancing requirements, we couldn't try the case until this past fall, where the CDC reduced the distancing requirements from 6 feet to 2 feet. So the case went ahead in New York, and there was a sentence imposed. And the question, one of the questions in my mind that I've been thinking about a lot is, if the case had gone first here rather than New York, what kind of a sentence would I have imposed under the facts as I understood them as the jury determined the case? The guidelines that we've worked out, or that I have established at this particular time, is 135 to 168 months. So, of course, that is one of the starting points. That's not the ending point, of course, because we have to consider the nature and circumstances of the offenses and the history and characteristics of the defendant and the other factors that the purposes of sentencing that we know about that reflect the seriousness of the offense, promote respect for the law, provide just punishment, provide adequate deterrence, and protect the public. So the sentence that I would have given probably would have been higher than the guidelines, probably because of some of the points that the government has indicated. Oh, okay. So Uncle Harry is like, listen, if this trial would have happened here first, I would have went above the guideline. Just like grown little boy said, he probably would have given him life. He probably would have given him life. That's what I think. What do you think? That's what I think. Then he says, I think that while the jury spoke on the issue of whether he had obstructed justice, there certainly was evidence that I could find by preponderance that he obstructed justice. Ooh, hold up. Hold the horses. What's up, wifey? What's up, mom? What's up, Kayla? What's up, my loves? So, no, Shireen, it's not going to help him get out of jail, girl. This is what he thinks. This is what he thinks. He thinks, I say like this. This is not going to help him get out of jail. But if he can at least sue the BOP officer, maybe for going into his private shit, then maybe I could see him doing it for that reason. That he wants to sue the person. So he wants to know who this BOP officer is so he could sue them. Who knows? I'm just saying. Okay. This is my opinion. So the judge is saying here, he would have given him he probably would have given him life. And he's saying that there certainly was evidence that he could find by the preponderance that Rkelly did obstruct justice. And he's also saying that, as the government pointed out, that the later guidelines, which would be in current now, would provide a higher offense level for the actual conduct. So yeah, Rkelly would have done life, according to Mr. Harry Linen-Weber, Judge Linen-Weber. Then the judge continues to say, so I have not come to a complete sentence. Baby, I need a fork. So I have not come to a complete sentence, and give me a soda as well. So I have not come to a complete sentence. But, of course, the elephant in the room, so to speak. No. Thank you, baby. A wonton. What you call that shit? The black stuff I use. Soy sauce. Thank you. You don't need that. Yes, I like to put soy sauce. Oh, you don't? Who are you telling? What? Put soy sauce in a fucking wonton. I always do. Hey, Nanya. What's up, Nuni? You got safely home. Thank God. You home now, Mama. I'm glad you had a good vacation. So the judge continues to say, so I have not come to a complete sentence. But, of course, the elephant in the room, so to speak, is what is he going to do as far as consecutive versus concurrent. And that is the issue that I'm going to start out with discussing. And then we'll end up with, because basically it's kind of irrelevant if what I end up sentencing him either way. So the question is, I'm not going to keep everybody in suspense. I'm going to provide for a consecutive sentence, but a minimal consecutive sentence of 1 year to add to the New York sentence. But I want to go into the reasons for my thinking upon which I based my decision. first of all, we start out with the sentence that everybody knows. At least as far as the judges who get involved and the lawyers who are involved in sentencing is to be sufficient, but not greater than necessary. So the purposes of sentencing, which I briefly had mentioned, reflect the seriousness of the offense, promote the respect for the law, and provide just punishment, provide adequate deterrence, and protect the public. Now, we start out, the seriousness of the offense is the nature and circumstances of the offense. And of course, everybody agrees that the nature of this offense is horrible, horrific. Abuse of young girls, sex tapes, tapes being in the public and cannot be, even though Mr. Kelly's minions spent hundreds and hundreds of thousands of dollars trying to get these tapes back. Uncle Harry said, hold on, wait a minute. He said, wait a minute. Let's not forget about your minions, okay? Your minions did a lot. He said, even though Mr. Kelly's minions spent hundreds and hundreds of thousands of dollars trying to get these tapes back, and obviously they were not able to do so, and they're out there in the public and they can't be removed. Yeah, that's sad. Even though Rkelly isn't the one who put those tapes out in the streets, he's the one who made the tape and someone put it out there. And I agree. I think that someone that put that shit out there should be arrested. There should definitely be some consequences for that person. Definitely. Because that poor little girl, she wouldn't have been embarrassed like that. Even though she would have been embarrassed just for the fact of knowing that he abused her. But, hold on. Oh. Okay, no. You know, he did this to her no matter what. He recorded her, humiliated her regardless. He showed it to his friends. People seen it. So the defendant's actions are seen on the tapes. The only possible ameliorating, I can't even say that, ameliorating isn't that he didn't. Ameliorating is that he didn't. Apparently, intend to traffic the tapes. He didn't. He certainly was horrendously negligent in how he kept them. Right. As I remember, I think Lisa Van Allen said that she found them in, I guess, a backpack sitting on the floor. And so she just helped herself to them. And that started out a rather Keystone Cop kind of operation in which these tapes spread out through the country. And Kelly's minions spent hundreds of thousands of dollars and effort trying to get them back. They were obviously unable to do so. This was not prepubescent sex child porn, which is a particular type. And there is, as I understand it, based upon Dr. Dietz's report, that Mr. Kelly is not a pedophile. But, again, see here, Judge Lennon Weber should have said he's not a pedophile, but he's a hebephile. That's what Judge Lennon Weber should have done. Corrected it and said that Mr. Kelly is not a pedophile, but again, these tapes got out there. And that's the nature and circumstances of the offense. And it's horrendous. And everybody agrees with that. And it's deserving of very, very serious consequences to Mr. Kelly. Now, the history and characteristics that both sides have gone into, Ms. Bongine points out that he had a fatherless childhood and he was raised in poverty, alcoholism in the family. He was subject to what has been a nice euphemism: adverse childhood experiences. Another word for sex abuse. He is marginally illiterate. He has a learning disability. His education is minimal. But contrast to that, he's a music genius. Multiple Grammy Awards. He wrote music for himself and many other famous musicians. His song was featured in a movie with Michael Jordan. All of a sudden, here's a person working on the street, and all of a sudden, he ends up with millions of dollars in cash without anybody really there to explain how he should handle himself. It is clear he wanted money. They said, "You don't need a credit card. Here's some cash. Just take the cash. Use it whenever you want to do it." Giving him hundreds of thousands of dollars in cash. One of the things that occurred to me during the trial, and we found out when we got the pre-sentence report, where was the IRS in all this with this money going out? This cash coming out of the bank, hand over fist. And we found out that I think there's $10 million worth of IRS liens against him currently, according to the PSI report. He did use some of the money for good. There is evidence that he gave money to many people who merely, some of the people didn't ask for it. And then the final thing is that rather than being a pedophile, he's, according to the diagnosis, as I understood it, other specific paraphilic disorder, meaning he has a problem with controlling his sex, which is pretty obvious from the evidence in this particular case. So, we have a case where it's always difficult when you impose a sentence because it's very easy to understand. One of the things that I think we should make very clear, that under the federal system, we have truth in sentencing. It's unlike the state of Illinois, where you get a day for good time, right? So that if you sentence somebody to 30 years, they're actually going to serve 15 unless they really misbehave. But in the federal system, usually you get good time of around 10%. So a 30-year sentence would be approximately 27 years as opposed to 30. So we're not talking about no matter what I do. Mr. Kelly is not going out the door after today. He's not going out the door in the next 10 years. And he's not going out the door in the next 20 years. Okay. Let me repeat that again. So, we're not talking about no matter what I do. Mr. Kelly is not going out the door after today. He's not going out the door in the next 10 years. He's not going out the door in the next 20 years. And one of the things that we should bear in mind, he is 56 years old currently, as I recall it from the PSI. And Ms. Bonjean pointed out, he has a life expectancy of not a hell of a lot more. I mean, not maybe 8 or 10 years. Now, of course, that's a life expectancy, which is based on statistics, not on he may outlive it. He could not live it. But it's important to note that he is 56 years of age and he will not complete his sentence from New York until he's at least close to 80 years of age. So the government is asking to add another 25 years, which assuming that which could be as much as 107 before he gets out. Right? So now, there's no question that Well, I suppose there's a theoretic possibility a person could live to be 107, but it would not be anywhere near what we could expect. So, his chances of surviving based on statistics, the sentence he already has is not good. But the sentence that the government is proposing, it would be, there's no chance. So the U.S. Sentencing Commission has indicated that a de facto life sentence is 470 months, but that's based on the average age of a prisoner receiving such a sentence, which is, I believe, the average age is 37. So the median age is 36. So you've got a big discrepancy of close to 20 years difference between what they consider to be a de facto life sentence. 470 months for a 56-year-old person. But a sentence, if consecutive, and if I give the sentence that the government is requesting, you're talking about 660 months, which is rather substantial above what's considered already to be de facto life sentence. Excuse me. Now, the guideline manual identifies age as a potentially relevant sentencing factor. That's 5H1.1. Life expectancy is a relevant factor for older offenders. Now, the Seventh Circuit case of U.S. versus Wertsinger stated that there is a worthy tradition that death in prison is not to be ordered lightly, and the probability of a convict who will not live out his sentence should certainly give pause to the sentencing court. So in cases that don't recognize age as a factor, where it's been refused is for a downward departure, not for an upward departure. Now, we get into the issue of the deterrence and protection of the public, which is a very important issue in sentencing. And that's been impressed by the government, saying that this man, he should not be allowed out where he's going to be doing exactly what he did before. And Judge Posner said, courts often acknowledge a lower rate of recidivism. I can't say that word right, but among older defendants. That's U.S. versus Jackson. So the specific deterrence here would appear to be relatively minimal. Defendant will be 80 if he's alive when he gets out of the New York sentence, or close to 80. And his method of operation, his MO, as come out during the course of the trial, was grooming young girls. Now, he was grooming the young girls when he was in his 20s, and he was a millionaire, and he was a superstar. When he gets out in his 80s, there will be few young girls that would be susceptible to his charms as an 80-year-old with no money and no prospects. So 80-year-olds are more interested not in grooming young women, but probably in their prostate and their arthritis and all the other factors that go into the aging process. So anyway, as far as if I was going to sentence Mr. Kelly, I would probably have, considering all the factors that I've outlined before, I would have probably had a variance upwards from the top end of the guidelines, which was 168. Again, I think there was some evidence, justification for the obstruction, and because of the increase in the current guidelines, so that in all probability, if I was sentencing Mr. Kelly as a result of, I would probably give him a sentence in the neighborhood of 240 months. So it seems to me that under all the facts and circumstances, that is a valid sentence, the 240 months, but I'm going to make the only part that's going to be consecutive will be 12 months. So the sentence would be 228 months concurrent, to be followed by 12 months consecutive. I'll have to work that out on the various counts, but that would be the sentence. What was the terms of supervised release of Judge Donnelly? Does anybody know? Ms. Bonjean says, I do, Your Honor. The judge says, what were? And Ms. Bonjean says, hold on, I have to pull it up real quick. The judge says, pardon? Ms. Bonjean says, I can pull it up real quick. Judge says, is it much different than what Mr. Alfer has suggested? I guess, put another way, Ms. Bonjean, have you reviewed the proposed terms of supervised release? Ms. Bonjean says, I have, Your Honor. Judge says, I think, well, it's relevant. It's not particularly relevant. Are there any that you object to? Ms. Bonjean says, I did not see any, Your Honor. The judge says, is the government satisfied with the proposed terms of supervised release? Mr. Pentake says, I'm sorry, Your Honor. Judge says, the terms of supervised release that were suggested by Mr. Alfer? Mr. Pentake says, yes, Your Honor. Those are acceptable to the government. The court says, okay, so I will make them concurrent with the terms of supervised release imposed by Judge Donnelly. Okay, so he's saying here that I will make them concurrent with the terms of the supervised release imposed by Judge Donnelly. Now, the terms that were posed by Judge Donnelly was that he had to be registered as a sex offender. He had to make sure that he did drug testing. He had to make sure that what else was it? I forgot. But those were some of the things. The judge says, so I will make them concurrent with the terms of supervised release imposed by Judge Donnelly. I assume she did have a term of supervised release in the sentence, did she not? Ms. Bonjean says, yeah, she did. The judge says, okay, now whether or not that can be done, Mr. Alfer, is that something that can be done, or is that just total confusion if there's differences? Mr. Alfer says, I do believe that there can be different sets of conditions. He has the New York conditions and the Chicago. So the judge says, I said making them concurrent. It's probably irrelevant anyway, based on the length of the sentence. So Ms. Bonjean says, she ordered 5 years supervised release, Your Honor. All right. Why don't we just leave it that way? I just won't do, I have to I just won't. Do I have to impose a term of supervised release? Mr. Alford says, yes, Your Honor. The judge says, okay. Why don't I just impose a 5-year concurrent one under the same? Is there any objection to that? If I make them under the same terms? Mr. Alford says, Your Honor, I will note the maximum term of supervised release is 3 years. The judge says, 3 years? Okay. 3 years concurrent to the 5 years then? And I'll waive a fine because of the inability to pay. Okay. Now, the judge here said 3 years, right? Now, the 3 years are running concurrent to the 5 years. So, in other words, after Rkelly serves his 20 years, he has to wait 3 years before he can go for any probation because it's running concurrent with the other probation hearing. The 3 years and the 5 years are running concurrent together. In other words. So he's got 5 years of probation for one and 3 years of probation for another of supervised release. So that means no matter what, Rkelly, he's not getting out of jail until he's in his 70s or in his 80s. Because if his conviction in New York should happen to get overturned, he has to complete the 19 years. He has to complete the 19 years before he can go for any type of supervised anything. He's got to do his 20 years. He's got to do it. So even if one got overturned, let's just say in 2 years, his appeal went up, right? So he's already down for 4 years, right? So we got 5, 6. So let's just say after 7 years, his appeal comes up. He gets granted his appeal, right? He's already done 7 years, right? Therefore, he will have to complete 12 more years before he comes out. So like we said, Rkelly ain't going nowhere. He ain't going nowhere. He ain't going nowhere. Just like the judge said, he ain't going nowhere. So the judge says 3 years concurrent to the 5 years then. And I'll waive a fine because of inability to pay. So the sentence is 240 months, 228 months concurrent to the New York sentence, and then 12 months consecutive to the New York sentence. No fine, term of supervised release. What did I say that I was going to impose? Ms. Bonjean says 3, right? 3 concurrent. The judge says 3 years concurrent under the same terms as imposed by Judge Donnelly. So the earliest that Rkelly could come out is in his 70s. And the latest would be in his 80s. Period. Okay. Sorry, guys. I'm still eating. I'm eating slowly. So the terms as imposed by Judge Donnelly, and also how many counts is the $100 special assessment for? How many counts? Mr. Penteg says 6, Your Honor. And the judge says 6. So $600 for special assessment. Mr. Kelly, you're entitled to appeal the sentence imposed. Do you understand that, sir? The defendant, Mr. Kelly, says, yes, sir. The judge says, I'm led to believe by Ms. Bonjean that you intend to appeal. And Ms. Bonjean, you will take care of filing the notice of appeal for him. Is that correct? Ms. Bonjean says, yes, Your Honor. The judge says, and Mr. Kelly, if you can't afford an attorney while on appeal, one will be appointed to represent you. Do you understand that, sir? The defendant, yes, I do, Your Honor. Mr. Alfer says, Your Honor, 2 things. 1, I just checked and I did misspeak. There is no mandatory supervised release. The judge says, all right. Mr. Alfer says, that must be imposed. There's no minimum term. The judge says, okay. Mr. Alfer says, my other question would be, if you do, the judge says, just to make it easy, why don't we just not impose a term of supervised release? Mr. Alfer says, the only concern with that, Your Honor, would be if something happens with the New York case and there is an appeal, then there would be no supervised release to follow in this case. The judge says, well, Mr. Alfer says, if for some reason that conviction was overturned or case vacated, I do believe that a term would be appropriate in this case to run concurrent. The judge says, all right, I'll make a 3 years term of supervised release under the same terms as imposed by Judge Donnelly. Ms. Bonjean says, concurrent, Your Honor. The judge says, pardon. Ms. Bonjean says, concurrent. The judge says, concurrent, yes. So, in the event that the sentence is vacated, now we proceed to the issue of restitution. I have a few questions that I want to raise on the issue of restitution. What did Judge Donnelly provide for restitution? Did she issue an order of restitution? Ms. Bonjean says, yes, Your Honor, she did. And we did have a restitution hearing. Her restitution order was approximately $370,000 roughly. I'm going to get the exact amount if you give me 1 second. And there, of course, 379,649.90. Your Honor, the restitution that was awarded there, I will point out, was based on actual data evidence of what it would cost to treat one of the victims, actually 2 of the victims, sexually transmitted disease that they claimed that they received or got from Mr. Kelly, and for a lifetime supply of the drug that treats that. That is a hotly contested issue, and it will be raised on appeal in the Second Circuit. But I want to make clear that that number came from an actual number from medication, 1 medication for the rest of their lives. It wasn't expert reports or any of the type of evidence that the government is trying to use here. In fact, I've never even seen anything of the type of evidence to be used in restitution. So that number was a number that was specifically connected to what the cost of a particular drug would be until the lifetime expectancy of 2 of the victims or 3 of the victims as I sit here today. And that's where that number largely came from. So $379,000 and change. The judge says, one of the questions I have, I guess, to the government is, and I appreciate the fact that the law provides that the ability to pay any restitution is not relevant, or it's not a defense to restitution. But does the government have any notions that there is something available somewhere? Ms. Pizzolo says, Your Honor, we have the same information that you do. As far as what's been, represented, and the judge says, the government is his biggest creditor at this time, the IRS. Would there be any basis that the IRS would yield to the defendant here, or will they insist on their rights as the lien holder? Ms. Pizzolo says, Your Honor, I think that's precisely why the statute says that these things should not be considered, because it's looking into a lot of different factors. We don't know what's going on or what's going to happen necessarily in the future. We don't, the courts have said that a defendant could win the lottery. That's the example the Seventh Circuit had used. So there's things that could happen in the future where he could, even if he has, a number of liens right now, that could change. The judge says, has the government done any research, or are you aware of any research by the IRS or by any of the judgment creditors that they found out whatever happened to his rights to royalties? Ms. Pizzolo says, no, Your Honor, we don't have that information. Ms. Bonjean says, Judge, I just want to point out, I actually represent Mr. Kelly on a number of these civil matters. And what I can represent to the court is that, A, it is entirely unclear. He does not know what percentage of royalties rights he even owns, frankly. That's one problem. Those royalty rights have been sold off over the years. It's not even clear what he owns. Second of all, the royalties that he has received previous to his Eastern District, New York case have now multiple liens on them. So what was held by Sony is spoken for 2 or 3 or 4 or 5, 6 times. At this point, if you take into account the default judgments, which now with interest are close to $10 million, in addition to the liens by the United States federal government, that is a part. So this idea that there is money out of there is, and the government has restrained everything. So they know what's there. They know that there's nothing there because they've not been able to get it. So all I can say is, yeah, I suppose you could win the lottery, but the reality is he's going to prison. He does not make music anymore. He cannot make music anymore. Whoever's leaking his music are the people making money. But he's certainly not getting any proceeds from any of his money. And whatever he has is spoken for. And we all know that his music isn't played because of the cancel culture and all that, and that's fine. But he's not earning income. And there will be no money unless something dramatically changes. The judge says, there was something on the internet. It says New Rkelly album, I admit, is a bootleg, not an official release, according to Sony. And I believe they quoted you saying that you knew nothing about it either. Ms. Bonjean says, "That's right, Your Honor. I don't think Mr. Kelly would have preferred that title if he was going to be releasing music. But that was not released in any official way. Unfortunately, as I mentioned, there's been a lot of financial exploitation of Mr. Kelly over the years, and a lot of his music has been stolen." The judge says, "Well, does anybody know who was responsible for that? Were there many sales?" Or Miss Bonjean says, "No, because within like 24 hours, as soon as Sony said it was bootlegged, it was taken off the internet. So I don't know who released it. We did try to investigate it, but we just don't know who released it, who had it. And he certainly made no proceeds from that. And I'm not sure anybody did because it was removed very quickly." The judge says, "Okay, well, I have reviewed your both sides, multiple submissions on the issue of restitution, and it seems that while the law does provide for restitution to the victims in this particular case, Jane, Pauline, and Nia, the government's submissions seem to follow the line similar to a tort case, a civil tort case, as far as seeking damages are concerned, although they phrase it in a particularly different way. But the difference, it seems to me, that the restitution is meant to be a simple or relatively simple procedure whereby the victims get together their actual expenses, the proven expenses, and bring them into the court or to the probation office or whoever. And then I get a report, and then the court would then issue a restitution order that defendant pay these bills. And I've gone through pretty carefully the submissions. The only really close to an actual item of actual expenditure is alleged by Pauline, who spent $42,000 for therapy services, most of which apparently were not covered by insurance. So I'm kind of the rest. They say that basically what they're saying is that they should have received all this medical care. They should have received all this therapy, all three of them, over the years. And therefore, Kelly is responsible for what they should have had to spend, what they didn't. So it seems to me that what you're really talking about is a claim for tort damages, which, of course, if there was a lawsuit and there were a multitude of lawsuits against him, which, of course, then you have the concept of discovery and depositions, so you can actually determine, cross-examine the experts who claim that this particular condition or that condition is casually related to the actual misconduct of Mr. Kelly. That's not the purpose, as I understand it, of restitution. The purpose of restitution is to reimburse for the expenses that they were caused to incur, and also to cause that for some future. But it seems to me there's been no evidence other than Pauline, I believe it was. One of them testified to $42,000. That was Pauline, who actually, and that would be, if she did, then that would be subject to the restitution. Obviously, future matters which haven't occurred yet could be if they're casually related. But I'm just having a difficult time getting through how to handle this restitution. So maybe I should turn it over to the government and ask you if you want to comment on my comments. Ms. Pizzolo says, yes, Judge. Your Honor, absolutely right. Your Honor's absolutely right. The restitution statute provides that the victims should be reimbursed for their losses reasonably projected to be incurred in the future. And that's in section 2259. That deals with the sexual exploitation offenses before the court. And that statute, Congress, and the case law that discusses it specifically points out is because the damage that is done based on these types of crimes is lifelong. And so people that have gone through that, and you heard it from the victims themselves today, they're still struggling. They still need help. And so what we've tried to do is put together information and assessments showing that that is still, one of many needs they have. But mental health care, you heard from the victims today, that is a top priority. It's expensive, and the defendant should have to pay for that, given that he caused them trauma by abusing them. And so, we've put forth the case law in our memo here. It's not an exact science. We can't predict with certainty, the years of therapy that will be needed. But in many cases, Judge Kendall's Whiteley decision being one in particular cited studies that show that it's a lifelong process. And so that's what we've come up with in terms of being able to estimate. And Your Honor can do that. You can estimate what will be needed based on the literature before you, based on Dr. Cooper's assessments that we put before you, Your Honor. So that is one of the main asks of the government, that you impose. It's mandatory. Each of these victims must receive restitution. And so the issue becomes the amount. And so there's a lot of different ways you can calculate the amount. That's one of the reasons why the government had, asked for additional time for Your Honor to take these issues under advisement. They are somewhat complicated in terms of assessing all the information. So we wanted to make sure we had enough time to address those, although allow defense counsel to weigh in on her arguments. And that's where the government's position is on this issue. The judge says, Miss Bonjean says, yes, Your Honor. The government continues to say that restitution is mandatory. And that is true if they meet their burden. It's not just you must give them a number. That is not the statute. They still bear the burden of demonstrating what the appropriate restitution number is. The government suggests that you can just pull a number out of thin air based on some scholarly article somewhere. And the article that they actually cite for those costs is an article that talks about what the cost of sexual abuse or rape is for society, not for Jane, not for Pauline, not for Near, but for society, the criminal justice costs. So it's completely inapplicable and should provide no guide for this court. Again, the victims are not entitled to restitution for what it costs the criminal justice system to prosecute Mr. Kelly. That is not, and that's not what that article is about. Secondly, they still have to show an approximate cause. Now, here's the unique problem with this case. This conduct is 25 years old. And so the proximate cause issue is it's a little more complicated. And some self-reporting, that is, that my hypertension or my, feelings about something are caused by Mr. Kelly is not. It should require a little more than self-reporting. I think we should at least be able to see if some victims have actually sought mental health treatment in the past. So, as the court pointed out, there is evidence that Pauline sought mental health treatment in the past, which I guess is an indicator and a cost. We don't have any receipts from that, but let's just say we take her at her word of that. But for instance, Jane, there's not a single statement that she's ever sought mental health treatment. So for them to say, well, we're giving a number to project it into the future, we didn't even hear that she was going to seek mental health treatment in her statement. She's not here to tell us that. That does not meet the burden. And I asked the court if the court is going to consider Dr. Cooper's expert reports. This is a woman that spoke to these victims on the phone and then diagnosed them with possible things that they could suffer in the future. I'm not even sure how she did it. This is not the type of evidence that is reliable. It's not subject to any adversarial process. It's not. She's not subject to cross-examine. And how would she determine, for instance, one victim's varicose veins are caused by Mr. Kelly? I mean, it's really outside the realm. And there's this assumption that, at least with Jane, that there's disabled for life, that she's disabled for life. I mean, there is an Eighth Amendment issue that comes up with excessive restitution awards. And they have an obligation to provide the proof. They have had years to do it. And what they provided was an expert report that they can use perhaps in their civil lawsuit, which, with how statutes of limitations are going, they probably can bring. So that's what they have provided. But this isn't evidence of restitution. My papers also demonstrate that there's a whole question of whether expert reports paid for by a victim are even admissible on standing grounds, It is the government that is asking for the restitution on behalf of victims that they are entitled to if the burden is met. But not, a plaintiff a victim herself has no personal standing. And these reports, unfortunately, just don't provide a sufficient nexus between this, what they're projecting into the future, which has no past to corroborate it, and there's no nexus. Dr. Cooper doesn't explain how she reaches the conclusion that these damages into the future are related to Mr. Kelly. And there's a whole 25 years in between that could account for at least some of this damage. We don't know. I mean, Jane wants to blame Mr. Kelly for the death of her father. Her death, her father died, as I understand it, from a heart attack or something of that nature. I mean, I suppose there's a theory out there, but we should be entitled to question that. It's a little far removed. It's not what restitution contemplates. And if we're going to put an emphasis on these reports, we should have the opportunity to challenge them in a meaningful way. So I would object to the use of these reports as some type of ground, some type of basis for damages into the future for the rest of these women's lives, when particularly since there's no history that supports that they would actually go get mental health treatment? Except with Pauline, I guess. She has indicated she did. Finally, with Nia, as the court knows, she already sued Mr. Kelly and testified at trial that she received a $500,000 settlement. So, I mean, and the sentencing guidelines allow for an offset. So, it's too far removed. The proximate cause nexus has not been demonstrated sufficiently. If the court is interested in having that type of hearing, we could do that. But I don't believe that it's appropriate, and we'd object to the reliance on those reports. Whew. So Miss Brongine broke it down like that, huh? She said, well, let me tell you something. I mean, she did her job, man. She did her job. She did her job. Give me 1 second, guys. Okay. Then the judge says, well, it seems to me that the restitution is not intended to be in the sense, well, it's adversary, obviously, but in the same sense of a civil trial in which issues of causation are very, very iffy, so that it would require plenty of time. If there was effort to do so for each side to hire experts and to depose them and then have a full-blown same thing as if you had a civil trial, because obviously these three ladies have been seriously injured and are entitled to some kind of recompense. But it just doesn't seem to me that restitution is the proper vehicle to do that. And so, with the exception of Pauline, I will award restitution of the $42,000. But it seems to me that as far as Jane and Nia are, Nia did recover. I thought it was $200,000 to $220,000, which she said is some. And affidavit, I think, that she actually recovered and her lawyer probably took the rest. So she would not be entitled to any. So with the exception of Pauline, I'll order restitution of $42,000 and deny restitution for Jane and Nia. Anything further? Ms. Pozzolo says, Your Honor, just for the record, this is the government objects to that calculation. And we just think that, based on everything Your Honor saw at trial today, the literature before Your Honor, the case law, child exploitation cases, victims need mental health treatment. So at a minimum, Your Honor, can estimate what that average hourly rate is. We included that information. You can bear that out a number of years. It's very important to the government representing this district and the victims that we need to ask for that, Your Honor. And we feel strongly about this issue. If Your Honor is not comfortable with, the reports that we provided, we can, put additional information in front of Your Honor. And you have the ability to hold this over a period of time. You can review additional papers and issues a separate order. We're asking that be considered. The judge says, I considered that, but it seems to me that what they should have done or should do is bring a civil suit against Mr. Kelly and then proceed accordingly. I appreciate the fact that he appears to be judgment proof, but as I guess I pointed out once, who knows, maybe if he gets a mega million, he'll get $1 million settlement, actually. But if you consider the issue, the situation, the government there leans of $10 million. As I understand, the IRS, that with mounting penalties and interest, that they double pretty quickly. So if it was 10 million, it's probably 15 or 20 million now. So we're not taking about any really practical way that we can do anything for these people. But it seems to me that they really should do is go the tort route and sue him for the damages that he obviously did cause them, but without specific payments, with the exception of Pauline, who indicates she spent $42,000. I'm going to deny the restitution for the others. Anything further? Miss Bonjean says, Judge, the last issue that I would like to just place on the record is that historically, when Mr. Kelly has been either found guilty in the Eastern District or sentenced, the Bureau of Prisons automatically puts him on suicide watch. And the policy, as I understand it, is he is supposed to be assessed because of the Epstein factor. When you're high profile, they automatically put you on suicide watch. It seems like, and it actually required me to file a lawsuit against the BOP in the Eastern District of New York because he was not suicidal. They put him on suicide watch, and suicide watch is in itself a pretty cruel and unnecessary for his own mental health. In fact, it creates mental health issues. So I wanted the record to be very, very clear here. Mr. Kelly was very aware of the sentencing, what he was coming into. He's already under a sentence of 30 years. He is perfectly understood what the consequences were. He understands his sentence here. He is not suicidal. And if the BOP conducts an appropriate assessment of him, they will find that he is not suicidal. So I want the record to be clear. I understand the court has its own limitations in how the BOP runs, but I do want to make it a matter of public record that I have spoken to my client. There are no surprises here, and he was expecting this, and there is absolutely no reason for him to be placed on suicide watch. And if they place him on suicide watch, that to me, that would be seen as an interpretation of punitive action that's unjustified. The judge says, all right, as you point out, that's an Article 2 or Article 1 job to do that sort of thing, not Article 3. And so the record will show that you have made that statement. And it's up to the Bureau of Prisons to make the decision, not for the Article 3 judges. Anything further then? Then Mr. Penteg says, yes, Your Honor. Hold on a second, guys. Okay, sorry about that, guys. Sorry about that. We're almost finished here. All right. So Mr. Pentake says, yes, Your Honor. The government moves to dismiss the forfeiture allegation in the indictment. The judge says, all right, without objection, the forfeiture is dismissed. And then Mr. Pentake says, nothing further from the government, Your Honor. Ms. Bonjean says, nothing from the defendant. Thank you, Your Honor. And that is the end of the proceeding, guys. So we did that shit. We did that. We finally finished it. We did that. All right. So it's messed up how these girls, Jane, especially Jane, didn't get any restitution. I feel so bad for her. And I honestly, I know if she goes to, like the judge is saying, to go and do a civil suit, she's probably not going to get anything. I mean, he's already broke. He's locked in other engagements with the IRS. So this is a problem. He ain't got no money to give. He's all funded out. He's done. He's done, guys. He's done. So now we know that Rkelly has to complete his 20-year sentence, just like the conditions of the New York trial. He has to do the full 20 years. He has to do the full 20 years. He's got to do 20 years in jail. If the New York should be overturned, he's got no choice. He still has to do 20 years in jail. He's got to. He's doing under the same conditions as New York, period. So there should be no more misunderstanding of anything. So what's up, Amos? Missy! Take Rkelly! What's up, mama? Truth Strong Warrior! Honey Bunny! Ashia! Aisha! What's up, I see ya, Aisha. Hi, mommy. What's up, Aisha? Diva Time. What's up, baby? So let's see what some of you guys had to say. If y'all has anything to say. He's like 10 million in the hole, but she should still sue him civilly. I mean, I say she should too, but what? I mean, is she gonna get anything? You feel me? You know what I mean? Is she gonna get anything? Will she get anything? I think Bill Cosby should be locked up. Age doesn't matter. Yeah, I think so too. Just because those things happened to him, RSK, doesn't mean he had to do what he did to those girls. And because he's slow, dumb, miss me with that bullshit. He could afford it. He should have got some help. Ain't that the truth? Kayla says, what's up, Kayla? Rockin' Robin. What's up, babies? This 504. What's up, Chula? Where is their king now? Have they flown him back to New York or nah? No, he won't be flown to New York. He will now go to a federal correction facility. That's where he's going next. That is where he's going next. That is where he's going next. He should have got some help. Nanya, no, never that. Te quiero, mi amor. I haven't been checking like I should. Oh, okay. There goes me. Hey, Purple, what's up, mama? Wifey, what's up, my wifey? And my girl Nanya in the building también. Mom Life, and everybody else. What's up, y'all? So, now, is Boho getting her funds? No, she's pro bono. She won't get shit, but it's the principle, Send. You never know. You know, you're right. You're right, Take. You know what I mean? It's the principle, but, you know. Amos! What's up, Papi? So, let's listen to thank you, Storm Monroe, for the work you do, brother. I'm going to play your live, and we're going to listen to Mr. Kelly speak. After his conviction, he has went to Storm Monroe, and he's still complaining about the same old, same old. Let's just listen to what he has to say. Right. So any law that was broken should be investigated. And you don't think you broke any laws, R. Kelly, that you should have been investigated? That's mighty weird. There's no sound? You don't hear it? You guys don't hear it? No sound? What the hell?